It's blue.
Now we see blue, so we're good? Okay, so,
I'm gonna check and make sure that it's,
we're gathered here for the, appeals board meeting, and we need somebody to make a motion so that we can call this meeting to order.
So moved.
Second motion, all in favor? All right, here we go. So let's stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Ready. So we have our agendas here. Thank you guys for being here tonight. And the first order of unfinished business are our bylaws. And so Jen has given us another copy of them. And does anybody have any major changes? I know we got these in the mail. Have you all had enough time to look at them?
So that's updated.
Yeah, she just
Okay.
updated that. Yeah, so with the first where it says the appointments, it had the old word of one and the Arabic numeral 2, so now it agrees 2 and 2, which is what the ordinance says.
Okay.
Yep.
Oh, okay. No, I haven't had a chance to go through and look at, unless you wanna
Okay.
just quickly go through and
So,
review.
yeah, so real quickly, I went down and noted that under paragraph 2 where it says officers and duties, we have paragraph A for the officers shall consist, and that's what she just added with our chairman, vice chairman, and the secretary, and then B was blank, so we took B out, and that has been moved up, so C is now up where B was. So the new copy starts off with, here's the duties of the chairman, and then paragraph C is the vice chairman. And basically, in the absence of the chairman, the vice chairman shall perform all the duties and conduct the business of the chairman. And under the secretary, which is now listed as paragraph D, it's what has always been here, and we added the line at the bottom, in the absence of both the chairman and the vice chairman, the secretary shall perform all duties and conduct business as the chairman. And we had talked about and voted at the last meeting that we wouldn't go any further for somebody running the meeting, because after that, you don't have enough for a quorum anyway. There wouldn't be 3 people here.
So you said B was removed?
Yeah, so in the original copy that you sent here, right here,
Yep.
there was just nothing under B.
Okay.
So we just moved everything up.
Okay.
One letter. So from the version that Jen sent us and what she printed here, that error was just corrected, that's all.
Okay, and it's also listing that if chairman's not here, vice chairman.
That's correct.
Okay.
Yep. And then if you look under the secretary, the last line of the secretary, we added, and if the absence of both the chairman and the vice chairman, the secretary shall perform all duties and conduct the business of the chairman.
Perfect.
So we're set up there. Everything was good down to there that I had seen through the conflict of interest. I had to look up indirect pecuniary interest to figure out what that is. It's monetary. College graduate, been to graduate school, I had no idea what that was. I'm like, okay, I might need to look that one up. So I'm not gonna make any money off of it, which is perfectly what it should be. And then we went down through here under 4, powers and limitations. These are just the bylaws, and there's not really a need to quote what the state law is that we were trying to follow. The law that had been referenced, which was Title 30 MRSA subparagraph subsection 4963, actually had been repealed. And I looked it up, and that was the one that said that it pertained to federally recognized Indian tribes. And if you get down into the subchapter 6, it said planning and land use regulation. If you read the paragraph above, it just talks about we can specifically, especially in section 4, where relaxation of the ordinance may be effected only in the areas of height, area, structure, size, and setbacks. It's listed under A, B, C, and D, and it's basically what we have to do with all the zoning. With the permissions, usually the height restrictions come into play, excuse me, when you're looking at shoreline ordinances. Depending on how far back from the water you are, like within 75 feet, you can't go over 20 feet or the same height of the existing structure. At 100 feet back, you can go 25 feet, or the height of the existing structure. and over 100 feet, you can go 30 feet high. But that's all within the shoreline zoning ordinances there. So we don't really need that title in there. So my recommendation, God, I'm not going to talk tonight. My recommendation is that we don't need to quote the actual main law, because we have actually covered it with the ordinance. The town has already said, yes, we're going to abide by the laws as set forth by the state, so we don't need to take the bylaws and start adding other constraints in there, especially when they had been repealed.
Excuse me.
Yes.
So it's saying that it's recording, it's
Yep.
saying that it's live, but it's not showing on the website.
Gotcha.
So if it's recording on there, then I can upload it afterwards.
Yep, yeah, and that's fine, yeah.
Okay.
No, that makes sense, and I've watched a lot of the selectmen meetings that everybody's still,
Yes.
and everybody's talking, but nobody's moving, so yeah, that'll be fine, but thank you.
It's good technology.
It's working for us. Right under the next section, after the lowercase a, b, c, and d, it says a variance is not justified. We just added the alpha out there because it somehow or another the Microsoft Word decided that was a duplicated alpha as opposed to an A period notifying paragraph A. So we had to add that, but otherwise the substance has not changed at all.
I know this is gonna be a little bit of a nitpick,
No, please, that's
but, we have section 4, paragraph A, and then we have, section 4, another paragraph A.
Uh-huh.
Shouldn't we just go to B, C, and D?
Yeah, well, actually, Jen, that brings up a great point. I think that A doesn't even belong in there.
No, the second A, B, well, the A, B, C,
Yeah,
the second A.
Okay, okay.
let me, yeah, you're right. What that needs to be, the problem is it's not indented the same as this point here.
I
See?
want to get rid of these three, A, B, and C.
No, we keep those. So this right here, you see where I had you add that A because I thought it was in reference to these.
Oh, yeah, I
Here's
switched
the
that
A.
over.
Here's the A.
Yep.
That should probably actually be a numeric 5.
Okay.
See, because it's still along the lines of the board shall have the following powers, but we're trying to state that a variance is not justified unless all the elements above are met. So does that mean that it becomes a 5, or does that just become a small I underneath this? What is the proper indentation there? Because what we're trying to make reference to is A, B, C, and D have to be met
Right.
before we're going to allow a variance, and they have to be met in their entirety.
Exactly.
So we just don't want to get in trouble with,
But you already started an A in the beginning here.
right, that was my error. I made that error.
Yeah.
But if you see how far out it is, it's at the same level as this A, so I guess that would be fine. Because that A is making reference to the board shall have the following powers, so.
I don't even know why you would need this A, B, and C, you just get rid of it, it's just a paragraph.
Well, it's out here, and that would just be the end of paragraph A, that's all it would be.
Understood.
Yeah.
But you don't, why do you need these 3 letters here? It's just another couple paragraphs. I don't see why you gotta call them out with a A, B, or C.
It just has.
Well, you could reference it.
You're right, it doesn't have to be there, it just makes an easy reference, but you're right. It doesn't really matter to me how we wanna show that.
I just do what I'm told, so.
No, I got you.
Do you eliminate the A from here?
Yep. From here?
No, in the beginning. Your first order powers and limitations, you get rid of the A and then just start it off and run down here, 1, 2, 3, 4, and then you have A, B, C, and D.
Yeah, probably be better.
Well, the rest of them all start off with the alpha. Each of the sections,
Oh, starts off
they
with a
all
letter.
start with an alpha, yeah.
Yeah,
That's why that A was not in there. That's why that A was not in there.
and
If we take the A out, then it references everything above.
Okay.
So it was right to begin with. So we'll just take that A out and it will just, the paragraph, a variance is not justified unless all elements above are present. And that references everything above. So we'll take that A back out.
Okay.
Thank you, ma'am.
Yes, sir.
Good job. I hadn't even realized that was a double A there. 4 for meetings.
To be honest with you, I just noticed.
No. That's perfectly fine with me. Are you kidding me?
Well, then just, it's reference A
Right.
that involves a variance.
Right.
Correct.
So it's not like a variance.
Correct.
Right.
Yep. So under meetings, nothing has changed there. We meet the second Monday. That has been added.
Don't we meet the second Tuesday?
Tuesday.
That's exactly correct, because this is not. Thank you, ma'am. This is not Tuesday. This is not Monday. The annual organization shall be the first regular meeting in the month of July. What that means, guys, is that we'll be voting again on chairman, vice chairman, and secretary in July. Because that's the annual cycle that we should be on, since we've been filling in and we had different people that took over and then Chip left to go do his job. Then this means that in July we'll do this all over again. Not the bylaws, we'll do the voting all over again for positions. Yeah, which will be fun. Okay, and then we have the regular business meetings, and this is our basically the agenda. Then we have it set up here. We've got, it's just, we have A's and B's on the actual agenda itself, but this is the order that we'll be going through. So we'll start off with our call to order, the pledge. Any agenda amendments that we have, in other words, if we have to change something on the agenda, which we're not, any public hearings, unfinished business, new business, acceptance of previous meeting minutes, facts and findings, so.
So do we vote on our minutes like we do at the budget meeting?
Yeah, so there's a couple of ways you can do it from Robert's Rules of Order, and that is,
You can either vote on them or with no objection, you can use unanimous consent.
yep. So you can either read them into the meetings, or you can just, somebody can make a motion
To accept.
to accept them as written. Yeah, that's all. So that can be done. So the voting, where we added to it, shall abstain from any vote. So if the said member is, has a conflict of interest. All matters shall be decided by a roll call vote. Is that how we want to do that? So I guess that would be, that's not for how we're running the meeting, that's for an actual appeal.
Right.
Yeah, so that will happen in that way. Because we're not deciding matters as we're meeting as a group. If the board has alternate members, the chairperson shall appoint an alternate member disqualified from voting, unable to
You
attend.
gotta
Oh,
do that
point of
for
order.
tonight so he can vote too.
Right, yes. Point of order.
We probably should have made him made Mike a voting member, full voting member tonight at
That's,
the beginning of the meeting.
it can still be, it can still be done now.
Yeah, because I can still discuss, it's when it comes up to the voting that I
Yeah.
have to be officially.
Right.
Right.
So I'll make a motion to allow Mike McChesney to vote to promote him as a full member for this evening's meeting.
I'll second it.
All in favor? Those opposed? Passed. You're voting. Good job.
Okay.
Thank you, that was good, that was very good.
Now, do we have to do that at every meeting?
Until we have 5 full members.
Or until they try to make me a full member without notifying me again.
So do you want to be a full member?
No.
Okay, just answer the
No,
question.
it's twice I've caught paperwork going through to make me a full-time member. And twice I've called them on it,
Right,
and
I am innocent, I have never pushed that through.
I had asked about it before, and they said it had to be applied for. I'm good.
Right,
And all of a sudden, well, your paperwork's going through. What paperwork? That's something that has to be applied for. So all of a sudden it happened again, and I'm like,
gotcha.
and I just gave a copy of my, I could probably,
Oh, that's what you handed Jen when you came in?
I'll give this to you so you can see this also.
Right.
it doesn't have to be a vote either. He just designates you a
Alternate.
person there, so it
Right.
doesn't have to go through a vote
It
to get
doesn't,
you to
right,
vote.
he can,
He just
the chair,
designates.
whoever is the chair of the
Right.
time can.
Yeah.
But this went back to the same thing where all of a sudden they stretched it out to a 3-year. Only sworn in for 1 year.
Gotcha.
So in June, I'm gonna have to either reapply or not reapply.
Right, right.
So we'll see how it goes.
Okay, that's right. That's fair though. That's good.
We won't pick on you till after July then.
That's right.
But
August.
it's just,
All bets are off until August.
you know, I don't want it to go through and then find out 6 months from now, oh no, that paperwork went through 6 months ago.
Gotcha.
We can't, or if we have something where I vote and all of a sudden somebody catches it
Right.
and they call us on it, now the vote isn't valid because one of the votes was not legit.
Okay, so we should go through this on the appeal procedure because there's lots of dates in here. So any person aggrieved by an action which comes under the jurisdiction of the board must file an application for appeal in writing on the form stipulated within 30 days of granting or the denial of a permit. All right, 30 days is defined at the date the official notification is issued and signed by the appropriate representative of the board of the town involved and shall be counted beginning with the next day. If the 30th day occurs on a non-working day for the town, the final date for filing an appeal shall be the next regular work date. That's fine. In the
Just a
event-
quick question, and
Yes.
this is more of a definition question. I presume, given how this is written, that 30 days means 30 calendar days.
It doesn't say that in the ordinance. The ordinance strictly says 30 days from the date of the written decision of the code enforcement officer.
Right.
So now the question is, should we define it as 30 calendar days, 30 work days?
No, because it says here in the bylaws, it says if the 30th day occurs on a non-working day for the town, the final date for filing appeal shall be the next regular work day.
Okay.
So
What does the ordinance say in reference to that?
That's just how I said it.
Okay.
Applicant for administrative appeal shall be received within 30 days of the written decision of the code enforcement officer or planning board, and not otherwise. So it counts the weekends, it counts holidays.
Yep.
If it's a Sunday and the town hall is closed on that Monday,
Correct.
it doesn't say that here, whether it's the day or not, so.
right,
And we can't change the ordinance, so.
correct.
Well,
At least not without the town voting for it.
We can't.
Yeah, right, right. That's exactly right. Okay.
is this some of the stuff that Chip was in the process of doing?
Yes.
Okay.
Yeah. And there was some that were very specific that I saw. We'll get to them though. But yeah, Chip, this has the original bylaws, and the work that Chip had done, but we had to go through and vote for something because after we voted on them previously, you're supposed to sign off on them. We as the board are supposed to sign, yes, we agree with that, and that document never
Yeah, we
was
voted
created.
on it again and then,
Right, and we never created that document for us to sign.
and there's still some possibility that this was never signed for in its original form.
It's very possible. Yeah. So, and what I'm advocating is that we get all these changes tonight, and we're gonna meet again on May the 23rd for the training session with the lawyer. At that point, we could wrap this up and sign it.
Could this, or is this something that we should fly by the lawyer?
Oh, we can.
And then while she's here, she can give her opinion. If we have to tweak it a little bit, we can, and then sign it.
I should probably talk to the Board of Selectmen. I don't have any idea what kind of budget we have to do other things with the lawyer.
Okay, I don't know the legal end of what we're changing.
Sure.
What we're changing is legal.
Right.
You know, if it's a matter of her going,
These are just
These are
bylaws.
ju- yeah, this isn't a,
This is
like a
how we're
legal
gonna
binding
function.
document. This is just how we run the meeting.
right,
Ordinance is what the no kidding rules
That's-
are.
That's exactly right.
So this doesn't need to go through a lawyer, I wouldn't believe. It's not a binding document, I think it's just how we run
Because it just
it.
pertains to us. and-
Correct.
Right, this is how we're gonna function. But it does have, and we do list the things in here from the ordinance, like the fee that you have to pay.
Yep.
No application sworn in document, payment prescribed upon receipt land review application documentation. Noting any missing information or required documentation. Yeah, see, when we were talking with Chip, we're not really, we're not talking about going out to do any more site visits. It's really up to the appellate to bring to us, here's the stuff.
Right.
Here's what we went through. Here was, I talked to code enforcement and I was told they won't even think about issuing a permit. Or I went to the planning board and best possible location doesn't work and here's why. And then we can listen to that and understand where they were and make a decision.
And that's part of what they have to prove to us.
That is absolutely correct.
And if need be, if all of us are looking at them kinda crooked, would you like to see it?
Correct.
Then we could say, yeah, okay, or no, we don't need to see it.
Yeah, I don't know how often it would be necessary to go see somebody's site. I mean, I had done a site visit a year ago and there wasn't a whole lot that I had garnered from it, but what we had talked about 3 months ago was that we should just put the burden of proof on the person who's been aggrieved, and then we can listen to them with an open mind, but we have to follow the law.
Yep.
For whatever decision we come up with, it's based on, here's what the state law
We're
says.
not here to prove it, we're here to make a decision.
That's exactly correct. That's a quasi judicial. Okay, the chairman shall schedule a public meeting within 35 days of the acceptance of the appeal application. When land use clerk, Jen, shall cause notice of the date, time, and place of such hearing, location, building lot, at least 7 days prior to the hearing, in accordance with the town ordinance. The cost of the publication to be borne by the applicant, so that hasn't changed.
So just for my own knowledge,
Yes.
it says the secretary and land use clerk shall do that, shall cause notice.
You could put n/or if it's two different people, I think.
Well, Jen comes up with all of the details and makes sure that the calendars are correct. And she's here full time for the aggrieved to be able to come up and to bring the check and to bring the documentation. That's a good question. The
So we should
secretary.
probably take the secretary out because you don't even deal with it. Jen will deal with that, right? So it should be just the land,
It should just be land use, clerk.
right?
Yeah,
Joe.
Cause she's lining everything up and making sure everything's paid for and all that.
So you're gonna get rid of secretary.
Yeah,
Yep.
we're not getting rid of you. don't even start going there. You're already whittling it down. No.
I knew everyone.
He's already pushing back. That's good. All right, and then we go through the order of business, and these are the last few pages that I have not gone through.
Under hearings in the ordinance, it calls out a $50 fee. Minimum of $50 fee paid upon submission of written notice of appeal. Would that be something that's in the hearings over here telling people that?
The appeal procedure, it says $150.
That's different. This is for, the $50 is for, I believe it's for publication, the cost of the publication.
Well, what we have in here is that the cost of publication to be borne by the applicant.
Okay?
That's right there in paragraph. It doesn't have a number. It just says, but these are the bylaws.
Okay,
So
got it.
the
It's
bylaws, we just basically said that the aggrieved is gonna pay for whatever necessary publishing is. So that's a good find.
Yeah, cause here it says a minimum of $50.
Right. Yeah, again,
is what it is.
we're not trying to duplicate everything.
Yeah,
You're right,
understood.
you're right, that we gotta follow I'm glad you got that there. Order, determine the quorum, decides purpose of the hearing, the board determines whether jurisdiction. Yeah, that's a good one to do, 3. The board determines individual hearing or parties, defines parties of action. Code enforcement shall be automatically, so the planning board and code enforcement and municipal officers are already automatically made parties of action.
Municipal officers, that's just the selectmen, right?
Correct.
Okay.
That is correct. Then they have to identify themselves, state their business. The board may also identify other witnesses who may be required to give evidence. Witnesses will not be permitted to cross-examine parties to the action. The chairman gives a statement of the case and incorporates into the record the correspondence from the reports of the board prior to the hearing, and this material shall be available for public inspection unless confidential records are submitted. The appellate is given the opportunity to present his or her case without interruption. The board and parties may ask questions of the appellate through the chairman. So in other words, nobody talks directly to anybody. Parties to the action are given the opportunity to present the case. The board may call its own witnesses, such as the code enforcement officer. The appellant may ask questions of the parties to the action of the board witnesses. All parties are given an opportunity to refute or rebuke statements made throughout the hearing through the chairman. The board shall receive comments and questions from the observers and interested citizens who wish to express their views to the chairman. That could be abutters, that could just be anybody. The hearing is closed after all parties have been heard. If additional time is needed, the hearing may be continued to a later date. All participants shall be notified of the date, time, and place of the continued hearing and the reasons, and all written testimony shall be available for public inspection. And the board and its consultants have the right to submit proposed findings and conclusions at any prior to the decision being finalized. The board may waive any of the above rules upon good cause shown. For example, if the board is reviewing a planning board decision for which a hearing was held and a complete record was made, a rehearing of all the evidence presented at the first hearing is not required. Because the record of the first hearing can be incorporated into the appeals board record. All variance approvals granted by the Board of Appeals shall receive certification within 7 business days of the approval finding of fact. Okay. That's all legitimate. Decisions by the board shall be made no later than 35 days from the date of the final hearing. The final decision of the board shall be made by written order, signed by the chairman or the chairman's designated alternate. Transcript, testimony, if any, and exhibits together with all the papers and requests constitute the record. Okay.
So we don't have to make a ruling on something the night of? Can we deliberate later? Can we just absorb it and dissolve it and come back at the next meeting and make a decision?
Well, you only have 7 days.
Okay.
No, it's 35 days from the date of the final hearing that we have to make a decision.
Yeah.
The 7 days is, the
Yeah,
variance approval.
right.
So once we make a decision, we've gotta notify them within 7 days.
Yeah,
Correct.
yes.
But we have 35.
But we have 35 days to make
So
a decision.
within that 35 days, if you wanna meet 3 days later because you wanna think about it, that is an opportunity, but if we have to really follow the calendar to make sure that we wouldn't exceed that.
Right, but if there's a lot of evidence and a lot of stuff that's presented, then we kinda like wanna just have some time to sit back and look at it all versus being compelled to make a decision that night.
Well, yeah, you have
35 days.
That can happen, but we do have that 35-day clock, right? So-
Well, that's right, so we could adjourn for 2 weeks to look over it.
I mean, well, that's part of why we're gonna do the training on the 23rd.
Okay,
And the lawyer will really spell out for us, because these 4 questions have to be answered, the whole yield reasonable return, need for a variance, unique circumstances, the granting of a variance doesn't alter the essential character, and the hardship is not a result of the applicant or a prior owner. So those are the 4 questions, that's all we get to rule upon, that's all we're making the decision, is if all of that has been met. And that's what the appellate has to do, is to come before the Board of Appeals and state his or her case, state their case. And within that, it would need to include the answers so that we would all say, yep, the majority of the quorum says, we agree, you have met this, you have met this.
but we still have the opportunity to
As long as we're not going to exceed a
35
time.
days.
That's correct.
Okay.
So it all depends on, because if you've got paperwork today, and you're not scheduled to meet with for the appeal until the 30th day, you're up against a wall for being able to get back together within 3 or 4 days to
Okay, so that's
Hit that
not
35 days.
35 days from when they present it to us.
No, it's 35 days from when they bring all of the
When it
paperwork
gets
up to Jen, that's
stamped,
right.
okay.
And Jen calls and said, Tillman, I've got something, you need to come look at it. Do we have all the paperwork here? We've got the $150 check. They're
Okay.
gonna pay to put it into the paper.
Okay, that's,
ticks
alright, so
there.
that, it's not from when they present to us.
No.
It's from when they
Yeah.
go.
When they
Okay.
give everything that Jen needs up here, it's a big go at that point, and that's when the chairman, whether I'm here or you're here to do it, that's when you have to scurry up here to see, do we have everything that we need? Because the clock is now ticking. And then Jen will come out here and check the calendar back there behind the door, find an appropriate date that we think we can
Okay.
squeeze it in with the time frame. And at that point, that's when you have to be thinking, that's 32 days, or that's 28 days. So now, we need to have this
Be able to get a
board
week.
meeting, that's correct.
Right.
We only have X amount of time after that, so we have to finalize it on that night, or that
Okay.
day, whatever it's gonna be, so, yeah.
Okay.
So you're saying the decision has to come from the time that they file the,
Yes.
this says not from the date of the final hearing.
Yeah, that's what I'm seeing too.
It doesn't say from the date that they process the paperwork, it's from the final hearing. So they come in,
Oh.
they do the hearing, we do the hearing, okay, yep, have a nice day, you'll be notified within 35
You can
days.
tell I stopped at paragraph D there, so.
Okay, so it is from the date of the hearing.
So you do have 35 days.
So we do have 30 days to mull it over.
Correct.
I stand corrected, you are right.
He has,
That's
once
exactly
that's done,
what
he
it
has 7 days to get his fact of finding done, and he's gotta notify like the code enforcement officer and or the planning
So we've
board.
got 35 days, but he's got.
He needs time after the
time to get
decision
it in.
to process his paperwork and
to
get
you.
everything done. So you probably really don't have 35 days, you have like probably 20.
No, but we can go on a 2-week recess. and-
Sure.
is. Sure. That's good.
Thank you for clarifying.
That's good, that really is. Thank you, sir. Okay, so, be made 35 days, the final decision on any matter shall be made by written order signed by the chairman's designee, all right. The board in reaching said decision shall be guided by standards specified in the ordinance in each case. In reviewing any application on any matter, the standards of the applicable local ordinance or state statute shall take precedence over the standards of these rules whenever a conflict occurs. So basically, the state wins. Ordinance and then state law, regardless of how we think it needs to go. Notice of any decision shall be sent by mail or hand-delivered to the applicant, his representative or agent, the planning board, code enforcement, and the municipal officers within 7 days of the decision. That's exactly it. A variance granted by the Board of Appeals must be filed by the appellate with the York County Registry of Deeds within 90 days of the vote to grant the variance. A variance not filed within 90 days shall expire and be deemed null and void. That's not the planning board, that's for the Board of Appeals.
Right.
Okay.
So once the decision's made, you or somebody at the town office has to go and put it in the registry of deeds
Oh, okay.
within 3 months, 90
The
days.
appellate, yeah. Yeah, whoever the aggrieved has to file that within the York County Registry of Deeds.
Okay.
That's assuming that the planning board said, no, you can't. The appeals board said, yes, you can. Now they have to go,
They have to take it to the registry of deeds and put it in there, so it
Correct.
can be put into the deed of whatever the
the
issue.
deed of record now is, it will have that relief
Correct.
listed. Okay, so any aggrieved party by decision, so that's appeal number 1. Reconsiderations, that's appeal number 2. Any party aggrieved by a decision or order of the board or a board member may petition the board to reconsider any decision within 45 days of its prior decision. A request to the board to reconsider must be filed within 10 days of the decision to be reconsidered. So even if we take 7 days to tell everybody, and we meet 34 days later and make a decision, within 10 days, the appellate needs to say, nope, I want you to appeal this again.
Yeah.
So what happens, say we agree with whoever's doing the appeal. say the neighbor don't agree with us, can they appeal that decision, or is it just the one that's doing the appeal?
Yeah,
No, just on, once we approve the appeal, if we give them a variance, that's it.
Okay,
They can't come in and say, you know, I appeal that variance that you granted them, they get the variance, it's done.
okay,
pretty much their recourse would be going to court.
Right.
It'd be,
That would be what the
attorneys in
neighbor.
court do.
But part of what we're doing is notifying abutters anyway in this whole process. So a vote to reconsider and the action taken on that reconsideration must occur and be completed within 45 days of the vote on the original decision. So they have 10 days to say, I wanna talk about it again, and they have 45 days to schedule it and have that hearing. The board may conduct additional hearings and receive additional evidence and testimony regarding the reconsideration during this time period. So in other words, if they have something else that they want to bring up, that they didn't bring up the first time that they sat with the planning board or sat with us, they can bring it back up. In this reconsideration, they can bring even more evidence that they believe that they have been wronged.
now do they have to pay again to go through the whole process again?
I don't see that. That's a great question. Is there anything in the ordinance that says you have to pay again? Cause this
So it's gotta be one of these three reasons right here.
Correct.
So they can't just come up and say, I don't like your decision, we're gonna do this again. It has to fall into one of these three things in order to be reconsidered for a second time.
correct. The record contains significant factual errors due to fraud or mistake regarding facts upon which the decision was based.
Does not say anything about the fees.
Yeah, I don't know that there's an additional fee. It's a single appeal. They're still arguing the exact same point. They're just bringing more. The board misinterpreted the ordinance and followed improper procedures or acted beyond its jurisdictions. They can come back for reconsideration. Or if a second application for a variance on the property where a variance was previously denied is substantially different from the previous one.
So who's gonna eat the cost of, say, sending a letter to the neighbors or whatever?
They're already eating that cost with the,
With the first one?
just ongoing.
yeah.
I don't think we'd have to notify them again, would we? Question for the lawyer.
Well, I would think you'd have to, like.
You would probably have to, cause they'd have the right to come down here, you'd have to
Right.
notify them, yeah.
Right, so does the town eat that, or do they eat that again? I don't know if it's ever happened before, but
That's a good question to ask the lawyer. That really is. Okay, and then they have to appeal to Superior Court. Any party may take an appeal within 45 days of the vote of the original decision to the Board of Superior Court. So, so in other words, if they hadn't eaten up their entire 45 days for the second consideration, and they wanna go to the appellate court to the Superior Court before that 45 days ends, they can.
so who represents the town? If it goes to Superior Court?
Isn't that our lawyer, our town lawyer has to represent them?
Question for the selectmen.
I'm just asking, I don't know.
Right. Or does the county attorney handle that?
I highly doubt it's the
I don't
county,
know, I don't know if
probably
he
the
does
town.
that. I've never heard.
And I do believe
Yes.
I could be wrong, but I believe the selectmen have the right to say, is it worth actually taking this to court, or do we just give it to them? I believe. If you read the state law, I think that's where it's at, I could be wrong, but I think it's in there.
That's a great question. But I think as far as the bylaws go, I don't think we don't have to answer that.
No.
That question doesn't have to be answered tonight.
No, but
It's a great question to ask.
Yeah.
It's a good question to know.
It's something that has to be in there. You know,
Right.
So, in case you've got something screwed up in here, and none of us have seen it, should we put a little blurb in here at the end stating that the ordinance supersedes any and
I
everything here?
thought that was already there.
I didn't see it, it could very well be.
It was the one on the decision. Yeah, all meetings. No, no, that's not it. That's not procedural minutes. I remember I saw that. I saw that in one of the paragraphs that we read that said,
So number D, under decisions, if you go to D, it does say in reviewing an application on any other standards and any applicable.
That's it.
ordinance
Yep.
states which shall take precedent. Okay.
Yep.
So it is in that.
yeah, it's there. It's there.
Right.
Because this is not an ordinance.
Yep.
This is just how we're conducting ourselves, and the public knows how we will conduct ourselves, and here's the rules that we're following. So you want to come make an appeal, here's how we're going to be doing it, and this is all we're going to be following, or what we have here in the bylaws. So do we see any other changes you guys think we need to have? You guys, I'm sorry, that's good in Southern. Y'all, is there anything else y'all want us to do?
I mean, there's not many changes, it's just a matter of, I'd like to go back and mirror one to the other and just make sure that it's good. Yeah, maybe the night that the lawyer is here, if we have, even if she's not gonna be here till 6, maybe we'll start at 5:30. So we can go over it real quick, sign it if it's good.
Well, that's what I would like to do. I would like to, when we have the training, if y'all are in agreement, that night we can get this signed, because I believe that we actually have, a case coming up that will be taking place in June, so we will.
She sent out the email.
Yeah, so we'll have something that we're gonna have to be, hearing and making a decision on. And we should have this in place before that.
Yeah.
And if we do it on the 23rd, and that meeting was on June the 9th, I believe, then they have the opportunity 7 days well in advance to have seen, here's what we have to do.
Right.
And then that party would know exactly what to expect when they come to talk with us.
So what do you wanna do? You mean like 5 o'clock, 5:30? What do you guys think?
I mean, that would be she's scheduled to come in at 6.
I believe that's the time. Yeah, I have to pull out the phone as well. I think Mike's gonna beat me to it.
I mean, would that be something to do, is either do it at the end or do it at the beginning?
Yeah,
If we do it at the end, then at least she'd be able to give us,
6 o'clock, no, I'm sorry, that's the wrong meeting.
I think it's a 6 o'clock, but do we do it before or do we try to, do it after?
well, Tom, we don't have no questions for her, which I don't think.
6 o'clock, you're right, May 23rd at 6
Yeah.
o'clock.
Yep.
And I would imagine she's probably getting paid by the hour. So
Yeah.
probably do it when
We
she's
don't
not
wanna
sick.
take her time.
Right, well, we could release her and then go on to unfinished business.
Either way, before or after don't matter to me.
Yeah.
Same here.
Well, if we do it after, then we don't have to change the announcement for when we're gonna be meeting next. It's already been.
And if there's
Right.
questions we have for her that come up between now and then with this, we could
We
change it.
can hear what she's
And then,
saying as we're
that's a
looking
good
at
idea to
our
do it
bylaws,
after.
so.
Yeah, I mean, like I said, as far as reviewing both of them, that I'll probably
Yeah.
do this weekend, but it's small little changes
Yes.
that is just basically typos.
We can do this. We can get Jen to send us another copy, from the things that we have shouted into the room.
Yep.
And we can get another copy emailed to everybody, and, then I would love to be able to make a decision on the 23rd. After we hear the lawyer, if y'all have any questions that come up that should be, lawyer specific, although this is not the ordinance, then we can, make notes,
Right.
pencil it in, highlight it, however you like to do it, and then we can ask her if we have any questions there. And her training may answer the questions that we have. I know there's gonna be a lot of them I'm looking for, so that'll come in handy. Okay. So do we have anything else to discuss about the bylaws? We will meet after the training on the 23rd. And,
We'll just add it to the agenda rather than change the agenda
yeah,
time.
with the goal being, even if it's not perfect, we can change this at any time. If what we've got is good, then all of our changes are noted, then we can sign it and be on our way and keep moving forward. And as we progress as a board, we find something else, we can always add it to it. That's the whole idea. It's a living, breathing document. It's not something we're trying to hold up in court anymore. All right.
I think it's good.
All right, then we're on to the next We're on to the next part, which is our previous minutes. So how do we want to proceed with minutes?
We can make a motion to accept minutes as written.
Yeah,
Okay, do I have a motion? Is there a second?
I'll second it.
All in favor? Those opposed? Carries. So your minutes are good.
Awesome.
All right, so does anybody have any other new business that we need to talk about? Okay,
No,
other business, are there any board member issues or comments, anything anybody wants to put on the record?
I think we're a good group here,
I agree,
personally.
I do too, I think it's a really good group.
no, that was, the only thing was my appointment and everything else, and we you read anyway.
Right.
So we're good on that with me until June.
Okay. I do want to, send a note, to Paul and ask him if they've found another full-time and another alternate.
I haven't seen it
To fill.
posted yet.
Yeah.
You know, it'd be nice if on
I can
the
ask the
town
question.
website that it should be posted.
It is, it's on there.
Is it on there somewhere?
It's been there. It's been there for a long time.
I just
You
haven't.
just gotta go find it. You gotta dig into it and find it,
Well,
under positions and
Maybe
open
bring
spots.
it up to the top on the front
Yeah, you
page
could, yeah.
that we're still looking.
So if you know somebody that you think would work well with us, or that would just want to be part of the Board of Appeals, they don't have to work well with us. It'd be nice, but that's not necessary. If y'all know of anybody, recommend they go to the website and apply. Because we have the two positions, we have one full voting and one alternate.
Yep.
Okay. So I will send that to, I'll send a note to Paul to ask him if he can give me an idea of if they've heard anything. And with that, somebody needs to make a motion to adjourn.
Motion to adjourn.
Second,
Second.
all in favor? We're out of here. Good job, fellas.
Awesome.
I don't like to waste time.
7:15, not 7:15, not 7:45 midnight.